right, good morning, everybody. For those of you who don't know me, I am Michael Scharf, the co-dean of the law school, and it is my great privilege to welcome you to this wonderful conference that Professor Juscelino Collares has put together. It's the second annual conference, and one of the things that Juscelino and I have been talking about for years is the fact that our Cox International Law Center, which is the 12th ranked international law program in the United States under the U.S. News rankings, has been known for a long time for public international law. We do have the great Canada-U.S. Law Institute conference, which is private international law, but we really wanted to make a big splash in the world of international trade law and customs law. And this is Juscelino's expertise, of course. He's on the NAFTA register of arbitrators, and Juscelino is also the associate director of our Cox International Law Center. And then in his spare time, he is the chairman of our faculty senate. So it is really gratifying to me that he has been able to launch this annual conference and that this has become a really big thing nationally, where people know about this, they tune in and watch our webcasts, and they know that if you want to know what is going on in the cutting edge of international trade law and customs law, this is the conference you need to be at. For the last 3 years, we've been blessed to have a judge from the U.S. Court of International Trade here. And once again, we're very happy to have our judge with us, which will anchor this program. So without further ado, let me turn things over to Professor Collares and wish you all a very successful conference. Thank you.
Thank you, Dean Scharf. Good morning. Welcome to Case Western Reserve University School of Law, second International Trade Law Fall Update. That's a mouthful. Thank you also for our sponsors, the American Society of International Law and the Customs and International Trade Bar Association, the Cox Center, and the Greater Cleveland Lawyers Group. I am Professor Juscelino Collares, and I'm your host. I see myself as a co-organizer of this event with the Honorable Judge Gordon, Leo M. Gordon, U.S. Court of International Trade Judge, to whom I feel greatly indebted, and from whom I flagrantly stole some ideas to put this conference together. I will introduce Judge Gordon and engage him in a roundtable conversation after some brief remarks. Now, please join me in welcoming Judge Gordon, the distinguished panelists and moderators, and our wonderful alumni participants. As the conference theme suggests, we are gathered here to discuss emerging trends in litigation, as well as the deployment of new tools that are ancillary or additive to the more traditional customs and trade remedy litigation context. These ancillary tools are quite varied in that some of them are new, the Enforce and Protect Act, EPA, those administrative proceedings under EPA, while others are old, sections 337, 232, 301, and reverse false claim act actions. They are also varied as to how they come alive. In one end of the spectrum, you have reverse false claim act actions. In most other cases, proceedings are instituted by beginning administrative proceedings before different agencies, namely U.S. Customs, U.S. Department of Commerce, United States International Trade Commission, etc. These enforcement tools, however, share one thing in common. They may all end up in the United States Court of International Trade. The U.S. Court of International Trade is an Article III court under our Constitution. The judges enjoy an appointment based on good behavior, typically for a lifetime, after being nominated by the President and confirmed by the U.S. Senate. Like the U.S. District Courts, it is a trial-level court with a rolling docket, meaning that cases are assigned to its judges as they are filed. Unlike the District Courts, the CIT has nationwide jurisdiction over a specific subject matter, cases arising under the trade laws of the United States. The court has an authorized complement of 9 judges from a variety of backgrounds, including government service, private practice, and academia, in a courthouse located in New York City, just across the street from the Southern District and the Second Circuit courthouses. It's on Duane Street. Nice black box, glass building. Today, the CIT has jurisdiction to review trade determinations that come from 6 different federal agencies: Customs, Homeland Security, Treasury, Commerce, the International Trade Commission, and the U.S. Department of Labor. Thus, the court has jurisdiction over litigation that helps set the rules of the road for the great economic engine with which the United States is blessed. Having the government always appear as a party in no way interferes with the variety of remedies the CIT can provide. In this respect, the subject matter-based CIT functions like any other Article III court. Cases may always be brought by private parties, importers, domestic industry, foreign producers, and foreign governments. Actions before the CIT obviously allege that are violations of our domestic law, which of course incorporates international agreements, but the court can provide concrete remedies, including declaratory relief, mandatory injunctions, the return of improperly imposed duties, etc. In sum, the CIT has all remedial powers in law and equity as conferred by the Judiciary Act upon the district courts of the United States, with the distinction that it is a national court with a nationwide jurisdiction. Two major types of litigation come before the court. The first major type, of course, involves customs litigation, which typically involves classification disputes under the harmonized tariff schedules of the United States. In Ford, for instance, one of the recent cases, Judge Gordon and I, that have been decided at the CIT, Judge Barnett, but Judge Gordon and I will discuss. The issue of tariff engineering is the ultimate issue. To be clear, tariff engineering is the principle that merchandise is classifiable in its condition as imported, and that an importer has the right to fashion merchandise to obtain the lowest possible rate of duty. Possible meaning legal, of course. The case involves commercial vans imported from Turkey as passenger vans, thus paying a lower import duty, 2.5%, from which Ford removes the second row seat after clearing customs, but still in the port area, only to deliver them as cargo vans. The Ford vans, if deemed cargo vans, would receive a much higher duty, tenfold higher, 25%. Other customs issues involve the value of goods, where they come from, and how they have been tested, etc. The second major group of cases before the CIT involves challenges to investigations by the U.S. Department of Commerce and the International Trade Commission, where anti-dumping and countervailing duties may be imposed. For example, 5 years ago, Whirlpool Corporation, a domestic manufacturer of large residential washers, came to Commerce claiming that washing machines from Mexico and South Korea were being sold in the United States at prices below those charged in their own markets, or at prices insufficient to cover the costs of the goods sold. It's called dumping. Whirlpool also argued South Korean producers received subsidies from their government. So Commerce investigated washing machine producers from those countries, found dumping as to Mexico and South Korean producers, and illegal subsidization as to South Korean producers. Upon the ITC finding that such unfair trade practices injured domestic industry, Commerce issued an order and imposed anti-dumping and countervailing duties. LG Electronics, a South Korean respondent at the agency level, came to the CIT to contest only the ITC's affirmative duty determination on the notion that if you kill an injury finding, you kill basically the Commerce can't issue an order. I hope my students remember that. So basically, they charged the finding of injury by the ITC, that the domestic industry had been harmed by reason of the imports of the dumped and subsidized washers from South Korea. So it's an injury challenge to an injury determination. Ruling on a motion for judgment on the agency's record, Judge Kelly upheld the agency's action on injury as supported by substantial evidence on the record and the order stayed in place. Substantial evidence standard is the most common principle, standard of review applicable in trade cases. Other matters that can appear in the CIT docket include also claims by the government for civil penalties as a result of fraud, gross negligence, or negligence in the importation of goods, suits for liquidated damages, and government suits on bonds to secure payment of duties when goods come into the United States. Then there's various other collection actions by the government. One should also be reminded that beyond these specific types of actions, so there are two major groups, essentially customs, trade cases, and then these, enforcement of these civil penalty types of cases. Section 1581I of Title 28 of the United States Code also grants the U.S. Court of International Trade broad and exclusive jurisdiction over any action commenced against the United States, its agencies or officers, arising out of any law pertaining to revenue-raising or non-revenue-raising tariffs, fees, duties, taxes, or quantitative restrictions imposed on the importation of merchandise into the United States or pertaining to the administrative or enforcement of such matters. The one major exception are actions reviewable by NAFTA panels, which, depending on how ongoing NAFTA negotiations go, may come back to the jurisdiction of the CIT. As you know, USTR has indicated that the United States wants to remove the trade dispute, the binational review on trade determinations from the NAFTA, meaning basically Chapter 19 of the NAFTA. As we conclude this introduction and transition to our discussion of the different topics in this second trade update, an important point to retain is that any member of the trade bar knows that he or she can come to the U.S. Court of International Trade with the confidence that the review will be conducted in accordance with the norms for established and uniform standards of review. And this is a big deal. You know what standards you're going to have, and you know that the court applies these standards in a consistent way. By applying these norms, the U.S. Court of International Trade has contributed to the achievement of the constitutional mandate under Article 3, that is the source of its original jurisdiction. I will now proceed to a roundtable discussion with Judge Gordon. We will have ample time at the end for questions and answers for members of our audience. I met the Honorable Leo M. Gordon over the phone 12 years ago when he was the clerk of the court on a desperate call to ask for some remand determinations that I was having a hard time finding, and which were essential to a particular empirical work I was doing. The data I obtained, thanks to Judge Gordon's invaluable assistance, helped me conclude my research. He wasn't a judge then. I don't think I would have gotten to a judge by just picking up the phone. But he was incredibly gracious, and he provided this data and really saved my summer that year. That was 2005. So last year, I reached out to him again to ask for help in creating a complete new trade update in Cleveland. He again came through, and we've been in touch since. Judge Gordon is a Phi Beta Kappa graduate of the University of North Carolina at Chapel Hill, obtained his degree from Emory University School of Law. His career began over 3 decades ago as assistant counsel to the subcommittee on monopolies and commercial law, Committee on the Judiciary, U.S. House of Representatives. All customs and trade attorneys present owe him a huge debt of gratitude, as he was the principal attorney responsible for the Customs Court Act of 1980 that created the U.S. Court of International Trade as an Article 3 court. Following his time with the judiciary, Judge Gordon served on the staff at the court for 25 years, first as assistant clerk, then as clerk of the court, until his appointment to the bench by President George W. Bush in 2006. As many here present, I know of his great dedication to public service, and I have been benefited very much from his wisdom and kindness. Without further ado, I give you United States Court of International Trade, Judge Leo Gordon.
Thank you, Juscelino, for those kind words. I'll start with the usual government employee caveat. Any remarks that I have today reflect solely my own personal views. I'm not here to speak on behalf of any of my colleagues or the court as an institution. Before we begin the roundtable interchange, I thought I'd make a few comments from about the 10,000 foot level. Some of this may seem fairly pedestrian, but for folks who don't regularly appear before the Court of International Trade or are much engaged perhaps in the administrative process and don't get a chance to litigate many cases, there's some things I think you ought to know about kind of the current state of affairs at the court. But by statute, the court has a complement of 9 judges. We have been in a circumstance, 9 active judges. We have been in a circumstance where we have been as few as 5 active judges in the last 2 years. Within about the last 12 to 14 months, we've gotten 2 new appointments. One, Judge Jennifer Cho Groves, who comes to the court from a private practice background, doing a lot of intellectual property work, and before that worked at the United States Trade Representative, going around the world negotiating intellectual property agreements on behalf of the United States. And before that, she was a prosecuting attorney in New York. We were also joined by Judge Gary Katzman, who for a large part of his career was at the U.S. Attorney's Office in Boston, Massachusetts, and for the last number of years served on the Massachusetts State Court of Appeals. They are both excellent and wonderful additions to the court. We also in the last, so now we're at a complement of 7 active judges and 5 senior judges, and in that same period of time, the court, either through a form of retirement going inactive senior, Judge Carmen, Judge Sakalas, and Judge Barzilai opted for that status, and unfortunately a year ago we lost Judge Pogue very suddenly one night to a heart attack. So, you know, in terms of complement of judges, the court's been under a little bit of stress, and it clearly has had an impact on our ability to get to the dispositional work. But on that front, the court's more than made up for it. Right now, the court, to this date, has issued 145 slip opinions for the year, and at that rate, the court will, in all likelihood, end the year with the single highest rate of dispositional slip opinions in the last 10 years and the 3rd highest in the last 20 years. So it's clear that all of the judges, active and senior, are getting to the business of the court and issuing the decisions that affect the litigants. There is no doubt that the work of the court is increasing. One of my colleagues recently taught an in-house course on trade law, focusing on the Department of Commerce, and in doing the research for that, we've learned that there are now 60 more dumping and countervailing duty orders on the books today as compared to a year ago. If you figure that a certain percentage of those are going to end up in challenges before the court, you come to realize quite quickly that the workload of the court and the bar, both government and private, and the stresses that are associated with those things are beginning to increase. And for those of you who are quite familiar with the work in the dump countervail area, you know, new orders spawn administrative reviews. So it's just not the judicial review of the initial investigation and the outcome both at the ITC and the Department of Commerce, but there's the going forward work and successive proceedings. So the reality is there's plenty of work for everybody, and dispositional stresses are going to continue. You couple that with what we understand is an increased focus by the executive branch on enforcement efforts we're seeing an uptick in the number of civil penalty and collection cases that are being brought at the court. Those have their own interesting and unique challenges, which I'll touch on in a little bit in the round table. The court works very hard in terms of its dispositional work. We have an internal benchmark of trying to decide cases in about 90 days. The reality is we hit that mark a reasonable portion of the time, but just given the workload and the complexity of some of the cases, we're not there 100% of the time. The court works very hard at making sure that no case stays on the docket for more than 365 days once it's ready for decision. And again, every once in a while, a couple of those rear their head and are on our plate for longer than perhaps they should be, but the court continues to work very assiduously at reducing that number and down to zero. In terms of things that directly affect the bar, the court works very assiduously with its advisory committee on rules in addressing improvements in the litigation process and concerns of both the bar, government and private, and the court. There have been a number of changes over the last 12 to 24 months that folks should be aware of. In the trade area, probably the two most significant changes have to do with creating a template and somewhat more automaticity around a statutory injunction to enjoin the liquidation of entries that are subject to trade litigation. Also, in an effort to streamline the process both between the CIT and the CAFC, the court adopted a rule that creates a unified appendix to the main briefing in a trade case, so then rather than the underlying documents from the administrative record being filed with each brief, there's a consolidated appendix that's filed at the after the last brief has been filed. That pretty much follows the practice and the rule. The rule and the practice in the Court of Appeals for the Federal Circuit. In the customs area, as a result of a decision a couple of years ago that raised some concerns about the timing sequence for getting an extension of time to remain on the reserve calendar, the court's advisory committee took a look at what we call the calendar management system in customs cases. My wife is trying desperately to get me to laugh here by interrupting me with her. So we just, it's just about to go into effect, if it hasn't already. There's a brand new calendar management system that deals with the reserve calendar and the suspension calendar. There's some new timing sequences for customs lawyers who are bringing denied protest actions to the court. You need to take a look at this. Also in the customs area, the court has had on its books for a while what we call a small claims pilot project. It's kind of running its course in terms of its initial timing. It very candidly has not yet been used. The court and the advisory committee are seriously looking at extending the program and finding ways to promote its usage going forward. I think two other things I might talk about quickly in the customs arena, both in traditional customs cases and in cases brought by the United States. It's the issue of summary judgment. The court adopted a rule a little bit more than a year ago that's akin to the practice in district courts, that when you file a motion for summary judgment, you need to file a separate statement of material facts to which the other side must respond. That ultimately consolidates all of the material facts into statements that are easily digestible by both sides and the court, as opposed to having to hunt and find them in the middle of a brief. If anybody's been following the decisional work of the court, you will notice that perhaps more frequently than ever before, the court is denying motions or cross motions for summary judgment. There are some significant questions that are out there about genuine issues of material fact in dispute. It doesn't mean that the cases ultimately go to trial. I think what's happening is the court is identifying areas where additional work needs to be done by the parties, and in certain circumstances, those cases have actually come back to the court and been decided on cross motions for summary judgment. The Ford case is probably most illustrative of that point. There seems to be some modest increase in use in the court's intra-court mediation program that's governed by a court rule and a set of guidelines. The focus there tends to be in one of three areas: civil penalty cases, classification cases that are one-offs. There may be a provision in the HTS-US that's been modified, and so a particular set of imports came in when the HTS read one way and now it reads another way, so you've got a one-off. And then we've seen some mediation work in the area of evaluation cases. In terms of another trend line, if you look about the last 18 to 24 months in trade cases, you'll note that the court has been dealing with the issue of the doctrine of exhaustion of administrative remedies, perhaps a little bit more frequently than it has in the past. I'll leave you to read those decisions and draw your own conclusion as to what contributes to that. With that, I'll stop. That's kind of 10,000-foot view trend line of things going on at the Court of International Trade. We still have 2 vacancies. There are no names that have been submitted by the President to the Senate, so the reality, given the pace at which things are moving, the likelihood is that those 2 slots will not be filled at least until the end of the spring of 2018. So the court's going to labor with a slight reduction in its complement, and so I can tell you on behalf of my colleagues, we're all working hard, but we also need your understanding that there's just so many of us, and if you want us to do a thorough and complete job, we ask that you have a little bit of patience.
Thank you, Judge Gordon. The theme of the conference is this, what we tried when we established it is we were trying to focus not only on, the classic, divide between customs and trade law, customs law and then trade law cases, but also and the traditional, actions that are filed or instituted under these particular areas. But we wanted to talk about, proceedings that are ancillary, that are new. Some of them are new, some of them are old, and because they, in a way, they are likely, especially in terms of the second panel, they are likely to become, certainly in terms of the first panel with EPA actions now, with Customs issuing its first decisions, determinations, you will see a rise in that end, as well as in the trade cases, the potential 232, 337s that have been with us for a long time will also be also part of this effort, which we see is part of an effort by the administration to improve enforcement, but not only, also by private parties, by domestic industry. And you also see, of course, a response by the importers, on the importer side, on that. So on this axis, on the notion of ancillary customs and ancillary trade remedies theme, Let me start by asking you a question, Judge, on a set of recent customs cases. United States v. Rupari, Judge Katzman decision, and United States v. American Home Assurance Company, a decision by Judge Moore of the Federal Circuit. These cases involve actions brought by the government to collect on civil penalties for fraud by an importer and to collect prejudgment interest on a surety, respectively. So how frequent are these actions in the CIT docket? And if you could comment on the major points of law in this area and give us your take on these cases. And then if you could go into Morex, because you've recently...
Well, Morex is AFA.
Yeah.
So on the enforcement actions by the United States, as I said in my opening remarks, we're beginning to see an uptick in these. And the enforcement actions are not only against the importers, but we're also seeing perhaps even an uptick in enforcement actions or collection actions vis-a-vis sureties. So let's spend a couple of minutes talking about these cases. In the question in Rupari was a bankruptcy filed by the defendant in the 592 civil action. Here, the bankruptcy was filed during the course of the civil penalty litigation. And the claim in the civil penalty action was for fraud. So, kind of breaking this down, the court tends to see more enforcement actions by the government in the civil penalty area for negligence or gross negligence. Civil fraud, much less frequently. The difficulty is, if you are a practicing customs lawyer, you know that the administrative process with respect to civil penalties takes a fair amount of time. So by the time the case gets to litigation, one of the challenges for the government and for the court is that there may not really be a live defendant. All right. So in Rupari, there was a live defendant, but the defendant filed bankruptcy. Right. And so the critical question there is, what's the effect of filing the bankruptcy on the civil penalty enforcement action by the government? And that was the question that Judge Katzman was faced with. And in the end, what he basically said was, no, the automatic stay, the statutory stay that one normally gets by filing bankruptcy is not going to be applicable to stay the civil penalty action. Now, this was a fraud case. So the open question is, would the result be the same in a negligence or gross negligence case? Some of the critical language in Judge Katzman's decision dealt with the statutory exceptions to the general rule regarding the continuation of the action, and Judge Katzman was concerned about some of the policy implications with respect to the bankruptcy rules and not allowing them to become a safe haven for wrongdoers. And there are two tests that Judge Katzman focused on, one having to do with pecuniary effect, and the other one was the public policy. And the court observed that the government was only seeking to fix a money judgment, not execute on the money judgment. So the interesting question is, if the facts are somewhat different in the next case, would you end up with a similar outcome or same outcome? And I think only, time is going to tell.
So what you're saying essentially is what the government was trying to do in the case is basically get in line.
Correct. It wanted
instead
to
of actually
effectively
enforce
register.
the debt.
Correct. Now, in American Home Assurance, and then there's a couple other cases, some that involve surety companies and some that involve private non-surety companies, importers. A couple of important things. In the American Home Assurance litigation, the government sought statutory prejudgment interest and equitable prejudgment interest. All right, so let me touch on the statutory prejudgment interest. There, the government was seeking interest under a statute, 19 U.S.C. Section 580, that provided interest in a suit on a bond at a statutory rate of 6%. The initial argument was that the government said that that statute was a penalty, right, and not a prejudgment interest provision. The courts never quite dealt with that issue. The long and the short of it was the Federal Circuit said 19 U.S.C. 580 applies. The private party defendant, the surety company, said that statute only applies to regular customs duties, right? Normal duties that you pay based upon classification, valuation, country of origin, et cetera. The government was suing here to garner 580 interest for the collection of anti-dumping duties, right? So the Court of Appeals said, no, it applies to both. 580 applies to regular duties and to dumping, theoretically, and countervailing duties, right? So then you had, so now you have statutory prejudgment interest. Now, what do we all know from our days in law school, right? Equity acts in the absence of a statute. Well, the Federal Circuit came along and said, yes, you've got statutory prejudgment interest, but we're not going to automatically say the government is not entitled to equitable prejudgment interest, and it sent the case back to the CIT to say, look at the circumstances and see whether equitable prejudgment interest would be appropriate. All right, so the follow-on has been that the CIT has had to look at, in each case, case-by-case basis, whether facts and circumstances, whether the equities weigh in favor of the granting of equitable prejudgment interest. Well, in the circumstances that we're in, right, where interest rates are low and you're being the government's being compensated at 6%, right, court came along and said, and the court did a full analysis. It looked at the interest rates over the period of time involved in the litigation and concluded that those interest rates were well below 6%, and said no, under those circumstances, the government was not entitled to equitable prejudgment interest. So equitable prejudgment interest is not automatically precluded. That's the bottom line of these cases. And it has to be a case-by-case analysis. Post-judgment interest, while the statute does not specifically apply to the Court of International Trade by virtue of 28 U.S.C. 1585, where the court possesses all powers in law and equity, the courts engrafted the post-judgment interest statute that applies in other forms of civil litigation, particularly in the district courts. The other piece of this puzzle, particularly circling back to 592, is that the court is finding itself dealing with defendants who are participating in the litigation all along the spectrum. Some fully litigating and defending their rights, and some who show up for a period of time and then exit the litigation, and then some who never show up at all. And so the challenge in those circumstances is typically not the issue of liability, and typically not the issue of whether the defendant owes the unpaid duties, but the real challenge lies in the determination of the amount of damages. And there's a decision involving Horizon Products in which I kind of lay out the panoply of options and approaches that the court has taken in dealing with the variety of scenarios where you deal with default judgment. So.
Thank you. Still on the customs side of the bar, the most interesting case is Ford, I mentioned in my remarks, which a tariff and engineering case involving commercial vans. This case combined old Supreme Court precedent, classification cases like merit, sugar cases. These are old, meaning 1891 type of cases. Merit, the sugar case, the Seaburger, the cotton plus wool sweater case, and Citroen, the pearls case. With the comparably more recent Federal Circuit 1994 Marubeni decision or test that looks into a vehicle's structural and auxiliary design. Judge Burnett's decision is under appeal, and I understand that comments here are very, we want to be circumspect. But what do you draw from this case in the sense that, what do you draw from the case generally, and today with the spread of rates being such, as tariffs over time have gone down, there might be still tariff engineering going on, but it may never get litigated because the differential in tariffs has become so small. In this case, the difference is tenfold. It's 2.5 if you import the vans as cargo vans. Do I have it up? As cargo vans, and 25% if you import them as passenger vans.
No, the other way around.
The other way.
The other way around.
Because there was a seat in the back.
Right.
So 25% if you import them as cargo vans, 25% if you import them as passenger vans.
So the tariff engineering, I'm going to assume most people know, but I'll take about 45 seconds. Tariff engineering, at the end of the day, is where there are consultants to industry who look at the tariff schedules and help the folks in the industry design their product in a way that takes advantage of the tariff schedules. Bottom line, the goal is to design the product and have it imported into the United States in a way in which you pay the lowest amount of duty. I think, candidly, no matter what the spread is in duty rates, somebody's always going to be engaged in that process, right? Because there are, between the different trade agreements that exist out there on a bilateral or multilateral basis, plus the fact that there's always some spread in the tariffs, despite the fact that there was at one time when the Doha round and the like were still alive and well, there was a drive to zero on tariff rates. But the reality is tariff engineering is going to be around. The degree to which it exists is kind of unknown by somebody like me. I think you'll have to ask, the customs lawyers, the regular practitioners in the audience, how frequently it occurs. But we've seen it candidly from time to time in litigation. I think for those of you who are old enough to remember the sneaker wars, for those of you who think that when you were buying sneakers in the 70s and 80s and you liked the designs, it was all about fashion and getting the customer in the store to buy them. Trust me, the percentage of leather or plastic, et cetera, on the uppers of the sneakers was all about tariff engineering and bringing those sneakers in at a favorable rate. Probably more recently, tariff engineering reared its head in the sugar industry, and Judge Barnett, in his two decisions, kind of outlines the more recent history.
The summary judgment and the final.
And so now you have tariff engineering. It showed up in the automobile industry, right, in the Marubeni case with the Nissan Pathfinder, whether it was a cargo van or a passenger vehicle, and now it shows up in the Ford case. I think the interesting observation about the Ford case is you're not talking about pre-importation activity. You're talking about post-importation activity while the merchandise it's gone through customs, but it's still in the port, right? So you have this interesting interplay, right, between the concept of what's the specific language? Guise and artifice, right? Guise and artifice, right? And condition as imported. Now, from a procedural perspective, there were two decisions in Ford. Judge Barnett, in the initial decision, denied the cross motions on summary judgment because there were factual issues relative to the cost of the reduced cost second row seat. Obviously, more discovery was done. The facts became clearer, and then the case came back and was resolved on cross motions for summary judgment. There was a lot of discussion about intended purpose. The court comments that it did not believe that it was relevant. And the court goes through a fairly detailed analysis pointing out the differences between the facts in this case while applying the Marubeni factors. I think it'll be interesting to see what happens at the Court of Appeals for industry, whether it's the automobile industry or other industries, and for customs lawyers and consultants. I think this potentially is the outcome at the Federal Circuit, and who knows whether it'll go to the Supreme Court beyond that. I think it's going to help shed light on whether tariff engineering is going to be alive and well going forward, or it's going to have to morph into something somewhat different along the way. I think one of the interesting things about the second decision is the court declining to engage in the use analysis, which emanated from the GRK decision by the Federal Circuit, which seemed to implicate that use can spill over into ao nomine classification cases, and the court here declined to engage in that analysis. I think the major takeaway on the Ford cases is stay tuned. I think it ultimately will be interesting fodder for not only for conversation, but probably some law review articles going forward.
We're about to run time. Let me just ask you one more question.
Sure.
And this a couple of trade cases that have been subject to remands. Itochu v. United States, which is a challenge to the Commerce final second administrative review determination on an anti-dumping matter, where Judge Rustani meticulously goes through the plaintiff's motions for judgment on the agency record, remands Commerce's final results based on a couple of those motions, while also granting the Commerce's motion for a partial remand. The other case is Meridian, where Judge Musgrave, I think, Judge Musgrave, he renders a decision and where he, in the opinion, disagrees with an interpretation that Commerce has on his second remand, but he says, I'm not gonna, this is, he mentions it in dicta because he basically agrees that the parties, Commerce and the importer, basically agreed to conclude the dispute by asking the court to sustain the agency's action. So my question here is two questions, and I'm going to ask you to be a bit briefer, if I may.
Sure.
This might be my only chance ever to ask for a judge to be brief. First, without addressing Judge Rustani or Musgrave's judicial temperament specifically, what factors drive a judge to pull the plug on further remands or makes him or her issue further remands?
Well, these cases raise two things: the question of fraud on the proceedings and transparency. That's kind of what's going on in the Itochu case. There was also a case called Hy-Vee Golden Bird that also dealt with the issue of fraud. And at the end of the day, particularly in the Itochu case, you're dealing kind of with the story behind the story. You know, when lawyers come to court, they tell the court what they want them to know. but there's always a story behind the story, and kind of the curtain got peeled back a little bit in the Itochu case, and Judge Rastani commented on kind of the peek behind the curtain, so to speak, and was basically very concerned about transparency and the integrity of the proceeding and the possibility of fraud on the proceedings, whether it's fraud before the agency or fraud on the court. And to a certain extent, that's also what was going on in Hybe Golden Bird, but more about the fact that fraud potentially was being perpetrated on the agency in the Hybe Golden Bird case because because the importer was basically importing for others who had a much higher duty rate.
Unfortunately, it's the possible untoward conduct is by the petitioner at the
Correct.
agency
Correct.
who casts a very wide net in terms of
Right. In Itochu, you dealt with a request to review over 200 respondents, which then got slimmed down. And the real question was the domestic making a private settlement with these companies, and therefore money that should have been legitimately collected by potentially collected by the government to offset the unfair competition behavior was going into the pockets of a private party as opposed to the government. And basically, Judge Rastani remanded to Commerce and said, ask the domestic a whole lot of questions and get satisfactory answers. The Judge Musgrave situation is not common, but it's not uncommon. I think it reflects the tension between the agency and the court in the understanding of what's going on in one of these proceedings and what's being decided. My view on it is that sometimes these things go off the rails because of the pressures of time, because the agency sometimes writes a C+ paper instead of maybe a B+ paper. They don't quite get to dot the I's and cross all the T's. And so as a result, some things are not necessarily explained as well as they could be, and you end up in a tension between the court and the agency. How many remands, kind of implicit in your question is how many remands are too many? Judge Rastani and her husband wrote a very interesting law review article on this. And basically the question is, when is enough that the court effectively will issue a declaratory judgment or an affirmative injunction and order the agency to do X or Y, or the court will step in and in itself act as if it was the agency and make the final decision. I just think it's a case-by-case circumstance. If you're dealing in a case where there's 2 remands, I would say to you, if I was handicapping it, highly unlikely. If you're dealing with a case where it starts to get beyond X number of remands, then I think the tension really starts to rear its head. And the question is, just exactly what's gone on in the case. And, we're just going to have to see. It's not, the under protest is not common, but it's not rare either. And I think it's just one of these things that is a case-by-case determination. And, there just may well be a disconnect. And if that happens, it gets sorted out in the mix.
Thank you. We have some time for questions. Anyone in the audience would like to ask questions, raise your hand. Yes, sir?
Just wondering, when the court is short-handed, does that make you think longer about setting precedent with less judges, or does that make you want to decide faster if it's like a quick, when you said there's a separate statement on summary judgment and just clear the backlog?
Well, I think each judge brings their reasoned decision-making to every case. Do I think that a judge takes less time or more time because there's a backlog? I think a judge goes about trying to do the best job that they can. in concert with the oath that they took. Judges are human beings. They understand the time pressures and the need to get the litigants answers. You know, for me, if I have more things in the pipeline, do I work longer hours? Do I work faster? Do I work harder? We all try to work as fast as we can and as hard as we can. I don't think that we would take less time and inadvertently, or I should say consciously, choose to take less time and shortchange somebody on our reasoned decision-making or justice. We're aware of the time pressures. We try to push the stuff out as quickly as we can. Some of it depends upon whether you've got a case that's got 2 issues or you've got a case that's got 12 issues. If you assume, for the sake of argument, that it takes a law clerk / judge about 5 days to go through and digest what's in the briefs, look at an administrative record, and write a first draft, and you've got a case that's got 12 issues, it's not going to get done in a week and a half, right? Whereas if you got a case that's got 2 issues, and judges will make adjustments. They'll understand if something's got a few more whiskers and move something up in the queue and move something else down.
As far as like the court being shorthanded, like you brought up current situation, you know there's not going to be new.
We just, the chief judge does a great job of distributing the cases evenly amongst the judges. The chief judge is very receptive to making adjustments when judges feel that they are burdened with overly complex cases that are sucking up a lot of time. And so, if I'm doing the queue 3 new cases and it turns out that I'm overburdened, I may get 1 or 2 new cases, and then, it'll even itself out over time. My next queue, I may do 3 cases, and I say to the chief judge, I've taken care of X, Y, and Z, and so now I'll get 4 cases, all right?
And X, Y, and Z is not the case.
No, X, Y, and Z is not the case.
Okay. Any other questions? Mr. Yarmick?
Your Honor, I had an interesting conversation recently on a 592 penalty case, and I'm hoping maybe you could pull the curtain back a little bit. And I'm wondering if you're getting the same message that I got, which was there are going to be more trials. And if I step on a plane to take a deposition, we're going to go to trial. And I wanted to ask if the court is hearing that same message from the government attorney, and if so, what is the court doing to prepare for that, particularly since you're short-handed?
The enforcement philosophy in civil penalty cases is something that's committed to the discretion of the Justice Department in consultation with its client. What I heard is what I reported to you earlier today. There is a likelihood that we're going to see an increase in enforcement actions in the civil penalty and collection area. The degree to which they go to trial, as opposed to summary judgment, I think is just going to depend. Do I know that the Justice Department has made some adjustments in personnel with respect to this issue? Yes. I think some of it's going to candidly depend upon the status of the putative defendants, right? There may well be just as many of those cases that end up in the default judgment scenario under Rule 55 because the defendant chooses not to defend or they don't exist anymore, right? So will there be more trials? We'll see. If it turns out there are going to be more trials, the court's prepared to deal with it. And in some respects, as strange as it sounds, right, being involved in a couple of day trial and a court making findings of fact and conclusions of law may ultimately be a lot simpler than sitting down and having to write a very involved decision on summary judgment. If it turns out that we've got a challenge, then like anything else, the court will go to the bar and find a way to work it out that will be in the best interests of all the participants, the government, the private litigants, and the court as an institution.
Thank you. A reminder to my students in civil procedure, just remember, Rule 55, it's not that rare, right? Default judgment. All right, any more questions?
Yeah,
One from this side?
in regard to tariff, would you call it tariff engineering?
Yes, tariff engineering.
You know, I mean, that's what lawyers do, whereas, you know, similar to a tax
Right.
intent, and so I found interesting this, what you call the standard intent, the background intent of purpose of the.
Right, that was one of the issues in the Ford case. One of the arguments,
It's like a really slippery standard. I mean, we're just like a mens rea analysis of what do they have in mind on making the product? It's to get the lowest tariff, which I think that's admittedly.
well, but there's Supreme Court law that basically says there's cases that deal with that. Intent was argued by the government, and the court basically said, we're not going there.
Very good, that makes sense. And then why do you think there's more dumping cases right now than there were a year ago? 60 more.
Dan? The answer is, as strange as it sounds, activity in the enforcement of the international unfair competition laws, dumping and subsidy law is counter-cyclical, right? So we're in an environment where there's a significant uptick. Dan's going to be in a much better position to address that at the Department of Commerce level, and the why and what domestic industry is saying to them as compared to the court. You got to remember, the court's in the most reactive position that one can be, where the courts in general, we're at the end of the process, right? We get what we get. We don't have any say in what comes in the door. And so if there turns out to be a spate of trade cases, there's a spate of trade cases, and we got to deal with them. Heather.
Thank you.
Right. I'll answer the second question first, all right? We're dealing with international unfair competition laws. Any time that parties, in this instance domestic and foreign, sit down and start to discuss things that relate to market share, pricing, et cetera, concerns, bells and whistles should go off, because you've got the domestic competition laws in the form of the antitrust laws. Not for me to say. I'm going to assume that the people involved were smart enough to figure out what they were going to do so that they didn't violate the antitrust laws. But I remember way back when I first got involved in this business, some of the scions of the trade field were actually folks who had made a name for themselves in the antitrust world. And they talked early on about the crossover and some of the potential problems. My view on it is courts are asked to decide certain things. I don't think it's the court's business to get into the behind the curtain, right? As I said, there's always the story behind the story, and if that story's not before the court, it's not the court's business. Where it's brought to the court, I think Judge Rustani legitimately raised critical questions that have to be asked and answered. To a certain extent, it's in the eye of the beholden as to whether that's ultimately relevant. But for Judge Rustani, under the facts and circumstances of those cases, it was relevant.
The big red flag there being the petitioner for the administrative review, listed 200 plus respondents and then dropped it down after an amendment, right, to.
Yeah. And I think what happened in the Nails case, right, it's the order of magnitude, right? You started off with an enormous request of companies in the administrative review, and then it got shrunk down. And so, if you've got any kind of tingly antenna, you know, they're gonna start jingling, right? And you're gonna be concerned. The question is, how far can you go as the court in that regard?
Thank you, Judge. Thank you very much. We have a 10-minute break, and
Thank you all. I appreciate it greatly.
our next panel will be